And let's go ahead and get started.
All right. Well, good afternoon. My name is Michael Dowry. Have the honor and pleasure of serving as receiver for the city of Chester. Today is Tuesday, May 9th, 2023. I'd like to thank you everyone for joining us here for our Municipal Financial Recovery Advisory Committee meeting. As always, we are joined by Mayor Kirkland on behalf of the city of Chester. Good afternoon, sir.
Good afternoon.
Good afternoon. We are also joined by Mr. Andrew Sheaf on behalf of the Governor's Office and DCED. Good afternoon, sir.
Good afternoon.
And on behalf of Delaware County Council, we are joined by Ms. Kelly Diaz. Good afternoon.
Good afternoon.
And as always, helping me to present and move the orders of business along, I'm joined by Chief of Staff, Vijay Kapoor, and Executive Assistant on loan from DCED, Mr. Cody Dill. Good afternoon, gentlemen.
Good afternoon.
All right. Mr. Kapoor, I think we're getting a little feedback from your microphone. All right. Now that this meeting is called to order, I'll ask Mr. Dill to share anything that we have on public comment.
Thank you. So since our last meeting, we haven't received any public comments necessarily pertaining to the work of this committee here. We would just like to continue to encourage the public to send their public comments regarding matters that are discussed with this committee to our email address, info@chesterreceivership.com, or on our website or social media pages. Again, that's info@chesterreceivership.com for any public comments that pertain to this committee. Thank you.
Thank you, Mr. Dill. All right. Well, I asked Mr. Kapoor to prepare another presentation for us here today to provide a status on on our recovery plan. Mr. Kapoor, are you ready to take it from here?
I am, Mr. Receiver. Let me go ahead and share my screen. What we'll be talking about today is an update on the Pennsylvania Supreme Court matter and the bankruptcy update. There's obviously a lot going on this month, and we just want to kind of keep folks appraised of it to the extent we can provide timelines. We're certainly going to try and do that in this update. And again, I'll go ahead and get started. Can everyone see it all right, by the way? Okay, great, thank you. So let me start with the Pennsylvania Supreme Court matter, this is the issue dealing with the plan modification and the appeal of Judge Seisler's ruling that included the suspension of administrative duties of elected officials. As those of you who have been following these MFRACs know, that matter is currently before the Pennsylvania Supreme Court, the Pennsylvania State Supreme Court. They will be hearing this matter on May 24th, so just in a couple of weeks at 9:30 a.m. in Harrisburg. This will be a live oral argument. It will be held in the main Capitol building, room 407. The Pennsylvania Supreme Court has its own, it's actually its own chambers in the Capitol building, and they will be hearing this case as well as other cases during their May session. Now, for those of you who are interested in watching or listening to this oral argument, the hearing itself is open to the public. We have been informed by the court that it's recommended that those planning to attend should arrive at 9 a.m. Unlike the Commonwealth Court hearings that some of you may have watched previously, the Pennsylvania Supreme Court only provides a live audio-only broadcast on its YouTube page. We have the link for it here and we'll certainly put it up on our Facebook page as well. That again is audio only, but it will be live as the argument goes. I do believe, and we're just trying to confirm this, that I believe that the state Supreme Court does record these audio only sessions and then posts them to its YouTube page. But again, this would be the page that you would want to go to listen to it. Those of you who are also government geeks, state government geeks, will know that the Pennsylvania Cable Network (PCN) also records these arguments, but unfortunately, they are not going to be showing them live. They are scheduled to broadcast the oral argument, which would include video as well as audio on May 30th. That is cable channel 186 in Delaware County. PCN also has an app that if you'd like to purchase or pay for, you'd also be able to see it there. Again, just so folks know, there are 5 other cases that the state Supreme Court will be hearing that day. This matter is listed as number 5 of 6. So it's very possible that there will be oral argument on other cases prior to this one, but just either stay patient or wait for the recording to come out. It is up to the court, obviously, to decide to hear its cases in any order it wishes. So again, that'll be up to the court. But these are a couple of opportunities for folks to watch or listen to the hearing. As part of the hearing, we wanted to talk a little bit about all the briefs, and you'll hear me use the word brief here a lot. In lawyer language, it's basically the papers or the filings. So all the filings on this matter, on the Pennsylvania State Supreme Court matter, are in the receiver's filings and the filings from certain elected officials. Those are all before the court. You can see those briefs on our website at chesterreceivership.com. And I believe it's on our documents page. And if you look further down on court filings, you'll be able to pull those. In this case, in addition to the briefs of the receiver, the briefs of certain city elected officials, what also happens sometimes is that other interested parties can submit briefs as well. They're referred to as amicus curiae briefs. In Latin, that means friend of the court. And what those essentially are briefs that are submitted that support the arguments of one of the parties. And in this case, there were 2 briefs that were filed in support of the receiver's position. One of those briefs was by the Pennsylvania Fraternal Order of Police. That's the FOP. The FOP is the union that represents approximately 40,000 law enforcement officers in the Commonwealth of Pennsylvania. And the other entity that submitted a brief in support of the receiver was Delaware County. And again, you can see those briefs on our website. Just a high level, and again, these are not very long briefs, but I do want to go into a little bit of the arguments or a little bit of points that both the FOP and Delaware County made in this matter. And again, they really both of those cases or both of those briefs really had to do with the issue of the suspension of administrative duties. The FOP focused most of their brief on the lack of pension funding in the police plan. And this is a direct quote here from the brief, saying that it's not a city that's capable of operating on its own without the receiver's directions, cannot be allowed to operate as usual, and that the economic security of its police officers and retired police officers is at stake. And so you can read the rest of this here from the FOP brief. But the push here is supportive of the plan modification and the receiver's actions. The other, I think, important point here that I'd like to call out in this brief, and also to go into it a little bit with the committee, because I think there's been either some confusion or we kind of just want to make sure that the facts are presented clearly. Is a direct quote from this brief is that, quote, the only reason law enforcement pensioners are even receiving benefits now is because of the receiver's action in making MMO payments in 2021 and 2022. Here, that section of the brief was talking about the underfunding of the police pension plan. This is a pretty direct statement here from a union that is representing both active as well as retired law enforcement officers who obviously have an interest in their pensions. Given some of that confusion with respect to the receiver's position and the receiver's actions with respect to pensions, we just want to kind of, again, go out here and provide the facts here of what actions have actually been taken by the receiver since he was appointed to date today. As most of you know, those of you who may be retirees, police retirees know, back when in June of 2020, when the receiver was appointed, the police pension plan had the equivalent of approximately 3 months of benefits to pay pensions in it. And it was there was a real possibility that the fund could run out of money to pay pensions. As of April of 2023, so as of last week, that police pension plan has the equivalent of approximately 14 months. Obviously, the plan has money going into it. It has money coming out of it. We make large deposits into the pension fund, generally on a quarterly basis from the distressed pension EIT. So you will see the overall amount in the plan fluctuate. The plan pays out approximately $550,000 a month in benefits, and so again, you'll see that number fluctuate a little bit. But as of the end of April 2023, we've got about 14 months of benefits in it. Again, that's much better than when we started, but still extremely bad. And we still have not been able to pay the approximately $40 million in missed MMO payments to all the plans, most of which is the police plan, from missed MMO payments and penalties and interest due to the prior lack of funding. So with respect to kind of the actions, how we've been able to get from 3 months to 14 months are these actions that I'm just going to touch upon briefly here. First and foremost, in 2021 and 2022, we ensured that the city made the annual actuarially calculated MMO payments to all of its pension funds, the police pension fund, the fire pension fund, and the officers and employees pension fund. This was the first time since that occurred. This was the first time that occurred since 2013. The second thing that was done was the receiver ensured that the distressed pensioned earned income tax money was deposited in the pension funds as is legally required. The city is able to levy a distressed pensioned earned income tax because its pension funds are so poorly funded. But what you have to do with that money is you need to put it in the pension plans. Prior to receivership, the city was using that money for general fund operations. So the receiver ensured that that money was put into the pension plans. The other item with respect to the distressed pension earned income tax was the rate that was being levied to residents was lower than what was legally required. And we discovered that, and the city raised it accordingly, resulting in more funding going into the plans. Now, what had also happened to residents, and those of you who are residents of Chester know that that also resulted in an increase in your earned income tax rate. And so now Chester is has the second highest earned income tax rate, only behind Philadelphia in the entire Commonwealth. But again, that's something that had to be done to comply with law. And then finally, and you all may remember this from presentations done probably about a year ago, was that the attorneys for the receiver believed that the pension board had been using the wrong final average salary to calculate police officer pensions, and directed the pension board to recalculate those pensions going forward. Now, obviously, there is a dispute about that from some retirees and from the FOP. There's a dispute about that. And that's going to have to be addressed through the bankruptcy process because litigations or actions surrounding it are stayed, they're paused. That is under the bankruptcy stay. Now, as part of this, and this came from the last pension board meeting where this issue did come up, the receiver has offered the pension board any documentation that the receiver's counsel relied upon in coming to this conclusion in the event that the pension board decides to do its own separate review. So we are happy to provide the documents that were reviewed in coming to that conclusion. And again, if the pension board decides to undertake its own separate review or the retiree committee in the bankruptcy matter, we're more than happy to provide that to those entities. And also, as some of you may know, there were memoranda that were written by counsel for the receiver that, again, we're also happy to provide. So moving to Delaware County's brief, there was also an amicus brief filed on behalf of Delaware County. Delaware County kind of focused more on how the Act 47 process worked in other communities across Pennsylvania, how it worked positively, and argued from their perspective that the lower court's factual and legal conclusions were supported, in their opinion, by the evidence, and that the actions approved by the Commonwealth Court in the amended recovery plan were fundamental to reaching a solution for the city. Noting that the existing ways of doing things, with the mayor giving discretionary powers to council persons to administer departments, will not solve the problems facing the city. The fiscal emergency will only be solved if the receiver has the power to push forward solutions as set forth in the recovery plan. Again, you can read those briefs in their entirety on our website, but those were kind of the main provisions, or the main kind of I would say kind of quotes that summarize both the FOP as well as Delaware County. Now, in terms of next steps, again, as I mentioned before, the oral argument will take place on May 24th, and we again provided how you may be able to watch that. In terms of a decision or next steps from that, there's not a deadline for the Pennsylvania Supreme Court to issue a decision in the matter. That is fully up to the court to issue it when it seems fit. But we'll say that the court is acting very quickly, as both the briefing schedule that the court issued, as well as the oral argument schedule, are much, much faster than what you would see in a typical Supreme Court case. So I think, again, without speaking for the court is moving very, very quickly in this matter. Now, during this litigation, just a final point, so there's no confusion on this. During this litigation, the court has temporarily stayed. So again, you've heard me use that term too, temporarily paused those appealed provisions of Judge Seisler's order, which included the suspension of the administrative duties of the elected officials. Now, that does not mean that the court has ruled against the receiver. Rather, an automatic stay, which is what the court did here, is normal procedure when the Pennsylvania Supreme Court decides to hear a case using King's Bench jurisdiction, which is what it did in this matter. So again, we're going to hear from the Pennsylvania Supreme Court on this. I think all of us can kind of say, hopefully we will get some finality as to a lot of these issues that have been dogging us over the last 3 years. And again, we're hopeful that the court will will provide clarity here on these issues. So that is the update with respect to the Pennsylvania Supreme Court. Moving to the bankruptcy update, there's just 4 items here that I want to touch upon here. Those have to do with eligibility. That has to do with the official retiree committee, the plan of adjustment, and mediation. So you'll remember me talk about bankruptcy eligibility. Eligibility is really the first step that a bankruptcy court has to take to find whether or not the municipality is eligible or meets the criteria for a Chapter 9 bankruptcy. In this case, earlier this year on March 14th, Judge Chan issued an opinion. She's the bankruptcy judge in the Eastern District of Pennsylvania, to whom this case is assigned, she issued an opinion finding that the city of Chester did meet the criteria to be a debtor in a Chapter 9 bankruptcy so that we could continue to proceed. On March 28th, certain elected officials gave notice that they were appealing the decision. No other party in this matter, except for certain elected officials, objected to eligibility and appealed Judge Chan's decision, finding that the city met the criteria for a Chapter 9 bankruptcy. There was a group of bondholders who had initially objected to eligibility, but they did not decide to appeal Judge Chan's decision, finding that the city was eligible for Chapter 9 bankruptcy. On April 11th of this year, the elected officials filed their statement of issues on appeal and designation of items to be included on the record. So that's a lot of legal words to kind of mean, basically, this was the questions on appeal that to the district court that were being asked to that they were asking the district court to review. And these two issues that are pulled directly from the brief are, number one, whether the bankruptcy court erred in entering an order and opinion determining that the appellants, so that's the certain elected officials, do not have standing to object to the city of Chester's eligibility to be a debtor under Chapter 9 of the Bankruptcy Code. That was one of the issues. The other issue was whether the bankruptcy court erred in entering an order and opinion determining that the city of Chester has met the requirement under the Bankruptcy Code that a debtor, quote, desires to effect a plan to adjust such debts and is therefore eligible to be a debtor under Chapter 9 of the Bankruptcy Code. So effectively, what that means is under the Bankruptcy Code, there is a provision that says that the debtor needs to demonstrate that it desires to essentially develop a plan of adjustment to adjust those debt. To adjust the debts. This is essentially saying that effectively, unless the elected officials say that they desire to effect a plan to adjust such debts, that the criteria to meet the Chapter 9 eligibility is not fulfilled. So the point I'll make over here is that the appeal does not challenge the court's finding that the city is financially insolvent. That's probably, I would argue, probably the main criteria here that a court looks at with eligibility, and that really looks at the financial situation. So these challenges are not challenging the financial situation. It's really an issue of who acts on behalf of the city. It kind of goes to the power of certain elected officials versus the power of the receiver. From the receiver's end, our view is that Act 47 clearly provides the receiver with the power to act on the city's behalf in bankruptcy. If you look to Section 706A9 of Act 47, it says, quote, notwithstanding any other provision of law, the receiver shall have the following powers and duties. And one of those listed in Section A9 is to file a municipal debt adjustment action under the Bankruptcy Code and to act on the municipality's behalf in the proceeding. And our view is that that's very clear to indicate that the receiver may act on behalf of the city and to continue to do what the receiver is doing. In her eligibility opinion, Judge Chan essentially, I'll allow her language and her writing to show what she said, which is that Act 47 explicitly provides the receiver with the authority to file a bankruptcy petition and act on behalf of the city in a bankruptcy action. As such, the City of Chester's Home Rule Charter is limited by Act 47. The General Assembly may limit the functions to be performed by home rule municipalities as it has done through Act 47. In fact, the city's home rule charter itself expressly limits the elected officials' authority by only granting them any powers and functions not denied by the Constitution of Pennsylvania, the General Assembly of the Commonwealth of Pennsylvania, or this charter. The elected officials' power to govern and make decisions for the city, therefore, is not an absolute power and is specifically limited by Act 47. And part of the reason that I wanted to kind of touch upon this was because the same issues that are really being discussed here in the bankruptcy matter are the same issues that are at the heart of the Pennsylvania Supreme Court matter as well. We think this is a very, very important case that the PA Supreme Court matter is going to be a very important case, I think, for Chester here, for how receivership is going to be conducted or can be conducted. And again, you can see here that these issues are also kind of touched upon in the bankruptcy matter, which again, which is why this case is so important. If we look at the next steps from on the eligibility issue, the eligibility appeal has been assigned to Judge Mia Roberts Perez of the Eastern District of Pennsylvania. That is a U.S. District Court. So you have District Court, Third Circuit Court of Appeals, and then U.S. Supreme Court in the federal end. And in this case, this is assigned to the District Court. The current briefing timeline, which may change, but at least as we are right now, given the submissions of documents, is that on May 30th, the brief of the elected officials is due. So that's in a couple of weeks. And then the city, which again, this receiver is acting on behalf of the city in this matter. So the city or the receiver's brief is then due on June 29th. And then there's a reply brief. The certain elected officials have the ability to reply to the city's brief. That is due on July 13th of 2023. It'll then be up to the district court to determine if and when to have oral argument on that matter. Again, that's generally up to the U.S. District Court judge, and that again, we'll find out about that likely at the end of July. But again, that's kind of where that process is. It is May 9th right now, so that even just the documents being submitted in the appeal in the bankruptcy matter, the earliest we're going to see some sense of when that oral argument will be scheduled is probably going to be at least 2 months from now. Second item I wanted to touch upon in the bankruptcy area is the official retiree committee. And here I just want to provide a little bit of a some facts for folks about what this is. If you're a retiree or related to a retiree, kind of what's going on over here with respect to how retirees' interests are being addressed or taken care of in the bankruptcy matter. Because obviously one of the issues is, you have many retirees, some of whom are police retirees, some are fire, some are O&E, some have been retired for a long time, some are spouses of retirees, some have just recently retired. You've got a lot of folks out there, who it would be very difficult for each and every one of them to have to come to bankruptcy court and argue or represent themselves. So what happens in a Chapter 9 bankruptcy matter generally is a retiree committee is created. And what an official retiree committee does is they act on behalf of the retirees. They basically represent the retirees' interests. The members of that committee are appointed by the U.S. trustee, who is a court officer. There was a whole process several months ago of doing that appointment where the trustee solicited interest in that, and there is an official retiree committee that is made up of retirees from the city of Chester in the police, in fire, and in O&E. Now, the official retiree committee can hire their own attorneys and experts. So it's not just that they create a committee and that's it. They are able to hire their own attorneys and experts. And the committee has done so. they've hired Jenner and Block out of New York as attorneys. Jenner and Block is a nationwide law firm. They've hired Flaster and Greenberg, which is another law firm here in Philadelphia as attorneys. They have hired FTI Consulting of New York as the financial consultant, also a national company, and the Siegel Company, also a national company as actuaries. I believe Jenner and Block, FTI, and Siegel all had experience in the Puerto Rico bankruptcy, representing retirees, and also representing retirees in the Detroit bankruptcy. These are national firms here who are, I think, well experienced in the Chapter 9 bankruptcy realm. And again, their role and responsibility is to advocate for the retirees through the retiree committee. So just two other items on the bankruptcy update. One is the plan of adjustment. Many of you, again, have heard me mention this term. It's one that I think folks need to get to know. And that plan of adjustment is really the goal of the bankruptcy process. That plan of adjustment, the goal is to comprehensively address the city's condition. And you develop a plan of adjustment, and the bankruptcy court will need to approve or confirm any plan of adjustment. That is going to take time, right? I mean, plan of adjustment basically is fixing Chester's situation and having a comprehensive fix for it, not just part of it. That plan will obviously, first you have to develop the plan, right? And then you got to implement the plan. That's going to take some time. And as we indicated in prior IMFRAC presentations, given that the city is relying on federal ARPA funds to fund operations, we really need to have that plan of adjustment developed by the end of this year so that it can be implemented in 2024, because the ARPA funds, again, those federal funds that the city is relying on to keep it afloat right now, they'll expire in 2025 if they're not spent down before then. So that deadline is very real. That's again why we were encouraging everybody here who is involved in this matter to really try and focus on the solutions here, because Chester has been in some sort of state oversight for like 28 years at this point, and we really need to focus on comprehensive solutions that actually address the city's financial problems, and hopefully to spend less time in court and more time around the mediation table. And speaking of mediation, let me talk about this here. The mediation process is ongoing. For those of you who don't know, Judge Chan has appointed Judge Mary Walrath, who is a bankruptcy judge in the U.S. District Court of Delaware, as the primary mediator. She has assigned bankruptcy judge Craig Goldblatt of the U.S. District Court of Delaware, specifically to mediate on issues involving the bond creditors. That mediation process is ongoing, and it's also a confidential process. The parties are legally prohibited from disclosing information discussed. The reason for that is so that information can be freely shared among the parties so that they can work towards a consensus solution, a consensus plan of adjustment. We really believe in the mediation process. It's something that the receiver actually made a motion for initially when the bankruptcy filings were filed back in November of last year. The receiver actually specifically asked for a judicial mediator to be appointed really immediately so this process could start. Because again, it's the receiver's perspective and desire that we reach a consensus solution, we reach a consensus plan of adjustment, that that addresses this of all parties involved, the residents, the retirees, other creditors, employees, et cetera. And again, we've indicated that the city is running out of time to do that. And so our desire here, and to the extent we can make another plea here to all the parties involved, we really have insurmountable deficits in 2025. Those are real. Those numbers may fluctuate based on data that we get from revenues and expenses as we're going on. But that 2025 cliff is insurmountable. So we need to be able to get a plan as quickly as possible. And we do hope through the mediation process, which again is confidential and which is being led by some very able and very experienced bankruptcy judges, that we will be able to move forward and to come up with a consensus solution, which again is going to then have to be approved in public by the bankruptcy judge, by Judge Chan. So that is the update that I have both on the PA Supreme Court matter as well as on the bankruptcy matter. And I'm happy to address any questions or hear any comments if the committee has any.
Thank you, Mr. Kapoor. As always, appreciate your thorough presentations. At this time, I'll open it up to the committee for any questions that you may have of myself or Mr. Kapoor. All right. Mayor Kirkland. Just 1 second.
There we go. I got it. I apologize. Thank you, Mr. Kapoor, for your presentation. You said, and I too hope that we can get through this court situation as quickly as possible. And my firm belief is that this is why we have courts, so that they can solve some of these disputes that come about. You said focus on solutions concerning bankruptcy, and I agree wholeheartedly, 150%. That's why I wanted to ask this question: where are we, or where is the receiver and your team with negotiations with CWA, Delcora, Aqua, American Water, and even Covanta? We have not heard anything from this end, from mayor and council end. Maybe you can give us an update on that.
Right. So what I would say is those issues are being dealt with in the mediation process. And again, because that process is confidential, we're not able to go into what's being discussed across the table. But those issues are being handled through the mediation process.
And through the mediation process, are any of our, well, when I say our, the city, for example, is our city solicitor privy to any of that information?
The city solicitor is not participating. No, the receiver is acting on behalf of the city in those negotiations.
Okay. So, well, thank you. And you did say it. You in your comments, you said that the court did not. It does not mean, this stay does not mean that the court ruled against the receiver. It also does not mean that the court, just for clarity, ruled against the city. Am I correct?
That's correct. Yes, sir.
Okay. And with the brief, if I may, Mr. Receiver, they talked about the brief, and I wanted to share something because I read the brief provided by both the FOP and Delaware County. I must say though, nobody from Delaware County has reached out to myself or any member of council that I know of. I did reach out to a member of Delaware County Council, And they indicated to me that they had no idea or understanding what it was I was talking about concerning the brief. Matter of fact, they had no intel on such brief, or they were not included, I guess, in those conversations with whoever the county council person was or persons were who put forth that support in that brief. But I did want to share, if I may, Mr. Receiver, something that I sent out just for the record, and I just wanted to be clear. I said, I'm writing in response to the article, the Pennsylvania FOP and Delaware County back Chester's receivers' efforts to strip city officials of duties, which fails to include a number of relevant facts about how Chester ended up in fiscal distress and the failure of county and state officials to provide an assistance over an almost 30-year period. The city of Chester has been under some form of financial oversight since 1995, including during the terms of 3 different Republican mayors, while both chambers of the legislature and county council were under Republican control. Neither the county nor the state stepped up to help Chester deal with the same devastating impact of deindustrialization cities across the country experienced. Now, as the city is showing real, verifiable improvements in public safety, education, and economic development, all of which state and county officials have been happy to tout, we are not being offered a helping hand, but being threatened with disenfranchisement of our residents through disincorporation. The single biggest driver of our city's financial problems and what is keeping us from making investments to build upon the progress Chester is making is the cost of pensions promised well before I became mayor. The burden of paying pensions for people who no longer live in city shouldn't be met with the threat of eliminating city jobs. Not only does it destroy the families who rely on that paycheck, it damages the city. While it is no surprise, it was the state, let me say that again, the state FOP, and not the local police, our partners in lowering crime to historic lows, that is supporting the receiver's bid to eliminate Chester. It is disappointing that county officials are too. The failure of previous councils to do what is right doesn't mean that negligence should continue. If employees are fired, as is likely if the city is disincorporated, the county will have to pick up those services from public safety to cleaning streets to maintaining parks and open space. We, the city of Chester, are part of Delaware County after all. It is beyond time to stop disrespecting the people of Chester. We have made significant progress without support, but now is the time to step up for us and not step on us. I say that in response to the comments in the brief that were stated by way of the FOP, and I'm assuming that all the members of Delaware County Council have signed off on this as well. Once again, I haven't received one call, one email, one letter, one notification from anyone from Delaware County Council. Also, and I won't speak too much on that, but the head of the FOP in the state level made some comments in his brief that were very disturbing. I won't address them at this point in time. I'll address them in another time. But I hope folks do read all of that, and I hope folks are listening today. This is a situation that has been hindering this city, as stated before, for over 27 years. And we're at this point now. But I think we're at a point where it takes each and every person. This is why it's important, I believe it's important that the judge does make a ruling to make sure that each and every person, not only on this call or on this Zoom meeting, participates in the writing of our financial ship, but those who are listening as well. That's all I have for right now. Thank you, Mr. Receiver.
Thank you, Mr. Mayor. Does anyone else from the committee have any comments? All right, Mr. Kapoor, would you like to respond to anything that was shared?
Just and again, I'm obviously not privy to any conversations that the mayor had with any of the Delaware County Council members. I will say that the Delaware County solicitor, had conversations with the county council members and prior to the brief being filed. So again, I obviously cannot speak to any conversations that the mayor had with respect to any of the members, but there were certainly members aware that this was going to be filed on behalf of the receiver.
And if I may, Mr. Receiver, respond to that as well. Once again, the Delaware County Council, Delaware County Council's solicitor is involved. The city solicitor is not, and I really don't see the fairness in that, but maybe that's because I'm not a lawyer and I don't understand the legal jargon.
Well, to be clear, this Delaware County solicitor is not involved in the mediations. He's involved with whether or not Delaware County decided to file an amicus brief in the PA Supreme Court matter.
So
just to be clear on that.
Just one question, one final question, then Mr. Kapoor. So the amicus brief, was that signed off by the solicitor for the county, or was that signed off by the county council member?
Well, it's just like the decision that respectfully City Council decided to do with the appeal. It's signed off on by a majority of the council. So just as the case in Chester, where not all council members are in support of the appeal, if you've got a majority, that's what you act. Again, I don't know what it was. I don't know what the numbers were in the Delaware County matter. I don't think you need to necessarily take a vote, but it's the same idea. If you've got majority support for it, then you act. Again, just like the situation in Chester with the bankruptcy appeal and the PA Supreme Court appeal.
Thank you. But I think that we were clear on the members of council who supported it and who did not. The member who did not. Quite frankly, you were very clear on that, Mr. Kapoor. So now we're saying that there are possibly members of county council who did not agree with this brief. I'm hearing this from you right now from the first time. So,
Mr. Mayor, you're putting words in my mouth. The answer is no. I don't know because I didn't have those conversations. So I don't know. I don't know who was consulted or who wasn't. So again, I mean, if I'm certainly sure that if someone wants to say they didn't support it, they can say it. But I don't know because I wasn't part of those conversations. Could have been unanimous. I don't know.
Okay, thank you.
All right. Well, thank you again, Mr. Kapoor, for today's presentation. And thank you to members of the committee for the exchange there. In closing remarks, I'll always add a reminder to visit the city's Facebook website page and maybe even their Facebook social media pages to stay up on the city's vacancies, actively recruiting for a number of positions. So when I encourage all to apply, please tell a friend. Our next MFRAC meeting is May 23rd, but the month of May is pretty heavy. City council meetings, 2 of them, state Supreme Court, federal court on Monday the 15th. There's just a lot going on. So we may cancel the May 23rd update and provide a more comprehensive update at the June meeting. As these dates go, it looks like at least once a month we'll have to touch base in this format to provide updates on the federal and state process. Court processes. Also want to encourage folks to reach out. We are available to meet on a one-on-one or small group setting. So please feel free to reach out to my office, Mr. Cody Dill, And our staff can assist with facilitating the meeting, introduction, sit down, whatever you would like, copies of materials, what have you. Also, please visit our website, chesterreceivership.com, as we pretty much maintain a library there of these presentations, court rulings, etc. All can be found on our website. Also, and the last thing I want to add is just that we did receive a communication from Councilman Morgan shortly after the meeting started, indicating that he would not be able to join us here today. But before we wrap up, does anyone have any questions of me? Well, hearing none, again, want to thank you for joining us here today. We are adjourned until our next regular communication. Have a good day.
Great day.